Most people treat asset protection as a single decision, an LLC for the rental property, an umbrella policy on top of the homeowner's insurance, quick conversation with their CPA about putting things in a trust. One move that makes them feel covered. Sophisticated families do not think like that. They think in layers, multiple layers, deliberate layers, each one adding friction, each one making the next attack more expensive, more uncertain, and far more likely to end in a settlement that is a small fraction of what was originally claimed. And here's the part most people miss. Complexity is not the enemy. Complexity is the strategy. The right kind of complexity is what makes structures expensive to attack and easy to defend. The wrong kind of complexity is what makes a structure look impressive on day one and collapse the moment a creditor's attorney looks closely. In this video, I'm going to walk you through how sophisticated families actually think, why they embrace layered asset protection, why they insist on discipline behind every layer, and why control, leverage, and legitimacy will always beat secrecy and shortcuts. I'm Ali Talai. I am a California asset protection attorney, also an estate planning attorney, and founder of Talai Law Offices. Before I jump in, I want to give you a heads up. Over the next several weeks, I'm going to be releasing a comprehensive series on offshore asset protection, Cook Islands Trust, Nevis Trust, Belize structures, the adaptive trust, equity stripping, multi-jurisdictional planning, Swiss banking, and how all of it integrates with the domestic foundation I build for my clients here in California. Before we get there, though, I want to spend a couple of videos laying the groundwork, because once you understand how sophisticated families actually think about protection, the offshore structures we're going to talk about in the series are going to make a lot more sense. If you want to see how I structure asset protection plans for real estate investors here in California, including an LLC, a holding company strategy, trust, and layered protection, I walk through all of that in my free asset protection webinar. The link is on the screen and also in the description below. Let me start with the misconception that sets most plans up to fail. Most people think asset protection is about eliminating risk, becoming untouchable, closing every door so no creditor can ever reach them. That is impossible, and sophisticated families know it. They know it is impossible. Anyone with assets and a public footprint can be sued. A tenant injury claim, a car accident with a six-figure plaintiff, a contract dispute with a former business partner, a divorce, a breach of fiduciary duty claim from a co-investor. None of these can be prevented just because your structure looks good on paper. They will happen or they will not, based on factors that have nothing to do with your planning. So sophisticated families don't chase invulnerability. They engineer friction. They build structures where a creditor who wants to reach the assets has to fight through multiple layers in multiple jurisdictions against multiple legal protections with no guarantee of recovery at the end. The goal is not to make the lawsuit impossible. The goal is to make collectability on the lawsuit so expensive and uncertain that the smart move for plaintiff's attorney is to settle for a small fraction of what they are originally demanding. That is what protection looks like in the real world. It is not a wall, it is a maze, and the maze is the point. Here is where I want to push back on something you may have heard. There is a school of thought that says asset protection plans should be simple, that complexity is bad, that fewer entities and fewer layers means fewer mistakes. I disagree. Layered asset protection works because it changes the economics of pursuing a claim. Every layer a creditor's attorney has to overcome adds time, cost, and uncertainty. A property held in a land trust owned by a California operating LLC, owned by a Wyoming holding LLC, and then owned by an irrevocable trust with equity stripped through a legitimate recorded lien is dramatically harder and more expensive to attack than a same property sitting in a single-member California LLC. That is not paranoia, that is math, and it is the math a plaintiff's attorney runs in the first 20 minutes of evaluating a case. So no, complexity is not the problem. Undisciplined complexity is the problem. Let me give you a real-life example. I had two clients who came to me last year, about the same time. Both own rental properties in Los Angeles County. Both had roughly about $4 million in real estate equity. Both of them had what looked like sophisticated multi-entity structure. The first client had 4 separate LLCs, a Nevada trust, a holding company, and series of intercompany loans. On paper, it was layered structured. In practice, it was a disaster. Money was commingled across entity bank accounts. Loan document existed, but they had never been recorded or signed. Annual filings had lapsed in 2 of the LLCs. The Nevada trust was a self-settled trust, which under California's choice of law rules means probate code section 15304 applies and creditors can reach right through it. He had paid for layered protection. What he actually had was layered exposure. The second client had a similar number of layers, a land trust for privacy, a California operating LLC for liability isolation, a Wyoming holding LLC for charging order protection, and a third-party irrevocable asset protection trust above it. But every single layer was disciplined, separate bank accounts, properly executed assignments, annual minutes, tax returns that matched the structure, a documented business purpose for every entity. When I stress test her plan against the 11 badges of fraud under California Uniform Voidable Transaction Act, none of them lit up. Her structure would survive scrutiny, same number of layers, same general approach, widely different outcomes. And the difference was not in the design, it was in the discipline. That is the lesson. Layered structures work. They are how sophisticated families have protected wealth for generation. But every layer has to have a purpose, every layer has to be maintained, and every layer has to behave like what it claims to be on paper. Layers without discipline, unfortunately, are not protection. They are an invitation. Sophisticated families think in terms of pressure points. Where would pressure show up first if something went wrong? Who would feel it? And who has the leverage to absorb it without making a bad decision? Because pressure is what forces bad decisions. Lawsuits create pressures. Tax bills create pressure. Family conflict creates pressure. And the person under pressure is the person who loses leverage at the negotiating table. I see this play out in my practice constantly. A family loses a parent and suddenly they're dealing with properties carrying massive built-in capital gains tax, trust terms that force distribution at the worst possible time, and siblings who cannot agree on whether to sell or hold. That is pressure coming from 3 directions all at once. If the plan was not designed to absorb that kind of pressure, the family starts making decisions out of urgency, not strategy. And those are the decisions they regret for years. Sophisticated families design plans that absorbs pressure rather than transmitted. They think about what happens during a lawsuit, during a tax law change, during a divorce, during a market meltdown or turndown, and during a death. And they build structures that give the family options in every one of those scenarios, not just the easy ones. Every decision in asset protection involves a trade-off. Protection versus flexibility, simplicity versus control, tax efficiency versus adaptability tomorrow, credit protection versus preserving the step up in basis, maximum offshore protection versus the ongoing reporting cost of an offshore structure. Instead of pretending these trade-offs do not exist, sophisticated family manage them intentionally. They do not chase maximum protection at any cost. They chase durable protection, protection that holds up under scrutiny in a California courtroom, protection that still works when the federal estate tax exemption changes or California adjusts its tax rates, protection that does not depend on everything going perfectly for the next 20 years. This is one of the reasons I am so excited about some of the structures I will be covering in the upcoming offshore series. There are now hybrid options like the adaptive trust that let you keep your structure domestic with no offshore reporting until and unless you actually need offshore protection, with a built-in mechanism that activates the offshore layer when a real threat appears. That is a trade-off structure designed to manage cost, complexity, and protection intelligently. We're going to spend a lot of time on it in the upcoming videos. Timing is where sophisticated families separate themselves most clearly from everyone else. Most people plan reactively after a lawsuit scare, after a tax surprise, after the family conflict that finally made it real. Sophisticated families plan before the pressure arrives, not because they are paranoid, because leverage only exists before you need it. Once pressure shows up, the analysis changes. Under California Uniform Voidable Transaction Act, which is codified in Civil Code Section 3439 and the following, transfers made after a claim is threatened or pending can be challenged and potentially unwound. There are 11 specific badges of fraud that courts examine. There is a 4-year window for constructive fraud. There's a 7-year statute of repose, which is the absolute outer wall. A challenge does not automatically mean a complete unwinding of the asset protection planning was done. The creditor still has to bring the action, prove the elements, and litigate it through. That carries real cost, real delay, and real uncertainty. But the position is meaningfully weaker than it would have been before a pressure arrived. What could have been a clean structure built years earlier becomes a contested one built under the worst possible conditions. We are going to go very deep on this in the offshore series that I was mentioning, because timing is the single biggest deterrent of how strong asset protection structure stands and holds up when it is tested. The final mindset shift is the one that separates plans that survive from plans that collapse the first time they're tested. Asset protection is not about documents, it's about behavior. You can have the best drafted plan in the world, the most sophisticated trust, the cleanest LLC structure, the most thoughtful layered design. But if your behavior does not match the structure, none of it will hold up when it is tested. Under California's alter ego doctrine, courts will collapse an LLC if you treat it like an extension of yourself. They do not care how well the operating agreement was drafted. They care whether you followed it. They care whether the bank accounts were separate, whether the records were kept, whether the distributions were documented, whether the entity was actually treated as an independent legal person it claimed to be. The plans that survive are the plans that lived correctly year after year, not just at the setup that they were done correctly. That part usually is done. Lived correctly for as long as the structure existed. That's the main part. So, if you take one thing from this video, remember this. Sophisticated asset protection is not about tricks or shortcuts. It is not about being simple for the sake of simplicity. It is about layered, disciplined, defensible structures that channel pressure, preserve leverage, and adapt over time. Layers are good. Friction is good. Multi-barriers in multi-jurisdictions are good. What matters is whether each layer has a purpose, whether each layer is maintained, and whether each layer would survive scrutiny when an opposing attorney goes looking for a weakness. If your plan only works when nothing goes wrong, that is not protection, that is hope. And your family deserves a plan that is built to hold under pressure, not one that is built to look impressive on the shelf. In the next video, I'm going to walk you through the exact stress tests I run every plan that comes into my office, the 7 questions I ask to find out where a structure would crack first when real pressure shows up. If you watched this video and wondered whether your own plan would actually hold up, that is the video that is going to give you the answer. Go watch the next video, and I look forward to seeing you over there.